Good afternoon and welcome to Boost CYC's new webinar series. My name is Jennifer Stanton and I'm going to be hosting the webinar today. Before we begin our session, there are a few quick housekeeping points to discuss. For any participants who are listening in French, click on the floor at the bottom left of the screen and select French. To see and follow along with the PowerPoint presentation in English, click Presentation, and that's at the top left of your screen. To follow along with the presentation in French, download the French version of the presentation by clicking on Documents on the right. Feel free to download the presentation in both English and French by clicking on Documents on the right. There will be a question and answer during the last 5 minutes of the webinar. To submit your question, please go to the toolbar on the right, and click Messaging and then Participants and type in your question. You can submit your questions at any time. And if you're watching this webinar in a group, please enter the number of participants in the group by clicking on Messaging and then Participants. We will now begin our discussion. The topic today is testimonial aids. By way of background, the Canadian Victims' Bill of Rights was enacted in 2015. And this is related to testimonial aids and is somewhat of a backdrop given particular articles that address specifically the rights of victims in the context of criminal proceedings. So, in general, the Act creates very clear rights for victims of crime and requires that those rights be considered at every single step of the process. In general, the Canadian Victims' Bill of Rights provides 4 principal rights to victims. The first is information, the second is protection, the third is participation, and the fourth is restitution. But as it relates to specifically the concept of testimonial aids and the rights of victims during the trial process, there are 2 relevant articles, those being Article 12 and Article 13. Article 12 is concerned with identity protection. And in particular, this relates to the rights that victims possess, and that translates in a criminal proceeding to publication bans. But according to Article 12, every victim has the right to request that their identity be protected if they are a complainant to an offense or a witness in proceedings related to an offense. And protection of identity can, in some instances, mean exclusion of the public of a proceeding, although those are quite limited. But more so, what this concept is, where this concept is evident is in publication bans that are imposed, protecting the identification of a victim or witness, or any information that could lead to the identification of a victim or witness. Article 13 specifically deals with testimonial aids, and it reads, every victim has the right to request testimonial aids when appearing as a witness in proceedings relating to the offense. And testimonial aids in this context directly translates to testimonial aids specifically articulated as being available in the Criminal Code of Canada. Testimonial aids, broadly speaking, refers to various items that can assist a complainant or witness with the articulation of their testimony and can, practically speaking, include screens that would shield a victim's view of the courtroom and specifically accused person, or CCTV, which would project an individual witness's image over a set of television screens rather than that person physically being in court. Either option is, in the context of the criminal code, meant to facilitate the ability of that witness to give a truthful account of their version of events. Again, by way of backdrop, another international convention that is relevant to the concept of testimonial aids and why those ought to be adopted by nation states is Article 16 of the UN Convention on the Rights of the Child, of which Canada is a part of or signatory to. Article 16 indicates that 1. No child shall be subjected to arbitrary or unlawful interference with his or her privacy, family, home, or correspondence, nor to unlawful attacks on his or her honor and reputation. And 2, the child has the right to protection of the law against such interference or attacks. The various concepts that have been discussed thus far, including concerns surrounding identification and the protection of identification of a child, are encapsulated by the UN Convention on the Rights of the Child, and in particular in Article 16, which recognizes the right of a child to have independence with respect to their own privacy, familial relations, and identity as a person, regardless of whether or not the person in question is a child. And so it is with these international concepts as a backdrop that lend to the inclusion of testimonial aids in Canadian law and jurisprudence. The Criminal Code of Canada specifically articulates in various sections, and primarily Section 486 of the Criminal Code, as well as others, the option or ability for one to make application for testimonial aids. And generally speaking, the case law, including the Supreme Court of Canada, have identified some general concepts as to why such provisions are necessary, and comment on what is indeed the parliamentary intent underlying these various sections. Some purposes of testimonial aids have been identified as, first, the truth-seeking function of the court. And that is, by way of explanation, to create an environment whereby particular witnesses, and specifically children, who can be considered more vulnerable and susceptible to suggestion, and manipulation by adults have a forum in which they feel comfortable to provide testimony. And so ultimately, if the function of the court process is a truth-seeking one, it need be the case that witnesses, including children, are able to provide information that will facilitate that function, or in casual words, to get at the truth of what happened. In a sense, testimonial aids indeed provide more of an even playing field, because children, as indicated, can be more susceptible and intimidated by the formalities of the court proceedings. The second purpose identified by our courts is that there need be special treatment of vulnerable witnesses. And criminal code provisions identify vulnerable witnesses as children, and in some contexts, specifically under the age of 18, but also other vulnerable individuals, including individuals that are able to demonstrate or indeed have a developmental deficiency such that they are more vulnerable. The next concept that the criminal code identifies and case law indicates is support for the right to testimonial aids is that certainly an accused person has a right to a fair trial, but that does not translate to an absolute right to face the complainant. Some concern that's articulated in opposition to application for testimonial aids is that an individual who's being accused of serious criminal offenses that faces high jeopardy should be able to face their accuser. But the case law and underlying concerns in relation to particularly vulnerable witnesses have identified that special circumstances can be made that still fulfill the requirement that an accused have a fair trial. In practicality, CCTV technology has developed to the extent that the images are quite clear and in fact arguably better than what is portrayed in the courtroom, because screens project clear and close imaging of a witness. And the function of a screen within the court has the effect of blocking out the courtroom, including the accused, for the witness, but not the opposite. The witness through the accused, through the screen is still in a position to make observation of the witness and his or her demeanor and disposition in court. And finally, the court has recognized the concept of a fair hearing not being, quote, the most favorable, end quote, procedure, and that is in relation to the accused person. So in other words, fair doesn't translate to having the accused in a better position than the witness as it pertains specifically to the receiving of evidence and taking into account the truth-seeking function of the court. The first section of the criminal code that is related to the general concept of testimonial aids is section 486.1. And that is the ability of a witness, and according to this specific provision, where the witness is under the age of 18 or has a mental or physical disability, the judge in the proceedings may order that that witness have a support person of their choice be present and close to the witness during their testimony. In the case of a child who's under the age of 18, The language specifically indicates that the judge or justice shall. It's mandatory language in this particular instance, and this instance is focused primarily on a witness who's under the age of 18 or has a mental or physical disability. The Criminal Code also provides provision for witnesses that do not meet these specific categories. So in other words, are not under the age of 18 or suffering from a mental or physical disability. In that instance, the language is not mandatory, but rather the judge or justice may, on application, make an order for a support person. But the specific language of 486.1 recognizes the concern underlying testimonial aids as it pertains to vulnerable witnesses, including children and persons with disabilities. In this instance, the language is mandatory, so the judge shall impose. However, the language additionally provides provision for an exception in the instance that the judge or justice is of the opinion that the order would interfere with the proper administration of justice. This provides some requirement for that person in opposition to the application to demonstrate that there is an interference with the proper administration of justice. Not to suggest that the onus shifts, but where the application is made, for example, by the Crown on behalf of the witness or the witness, there will need, if there's a contested hearing, be a basis to demonstrate the need for the application. The application, additionally, is one that can be made by the prosecutor, but the witness, him or herself, may make the application as well. Finally, the provision under 486.1 indicates that the witness is in a position to choose whom they wish the support person to be. This may have the effect of causing conflict in relation to an order made by the court for an exclusion of witnesses. If that is the case and the support person being proposed is also a witness, this may be an example of where a judge finds that the order would interfere with the proper administration of justice. Practically speaking, it is more often the case that a support person will be independent in the sense that they do not have necessarily a familial or close friendship relationship with the child or witness. Rather, they may be a representative from victim services or Boost. There are exceptions to that, and a support person may in fact be someone other than victim witness representatives or Boost. But the circumstances of the specific case will dictate what is appropriate. And if a child's family member is a witness, it more likely will be the case that that person cannot serve as a support person pursuant to 486.1. As I indicated, there is provision also under 486.1 that on application of a witness or prosecutor with respect to a witness, a support person can be ordered to be in close proximity to the witness while that person is testifying. Otherwise, if the judge or justice is of the opinion that the order would facilitate the giving of a full and candid account by the witness of the acts complained of, or would otherwise be in the interests of the proper administration of justice. This specific provision allows for a witness other than a child under the age of 18 or a person with a mental or physical disability wishes to provide their testimony with the facility of a screen or with the facility of a support person. In this instance, the application of the order considers whether or not the support person would enable the facilitation of a full and candid account by the witness. This provision is recently amended, and specifically as it pertains to the word facilitate. There is some thought that this lessens the onus by the individual making the application, specifically with the implementation of the word facilitate, because of course facilitate in its common meaning means to make easier, and that arguably is a lower threshold with respect to what proof must be demonstrated in order for successful application for a support person. It may be where there is opposition to the application under 486.1, need for a hearing to be held. And where the order is discretionary, the court, and specifically the code, articulates various considerations that a court may give. Though the list articulated in the criminal code is not exhaustive, but may consider points such as the age of the witness, and it may be that the witness is very close to the age of 18, for instance, the witness's mental or physical disabilities, if any, the nature of the offense, and in particular, if the offense is a sexual assault or sexually related offense, it may be the instance that the facilitation of the taking of that person's testimony or full and candid account of their version of the events can be accomplished or supported by the imposition of a support person, and that the need is greater for such sexual related offenses. The nature of any relationship between the witness and the accused, and in particular, if there was allegedly a power imbalance between the parties such that the accused occupied a position of trust or authority over the alleged complainant, and if there was a significant age difference between the parties, if the accused occupied a parental role or spousal role, those would be factors that the court would consider. Whether the witness needs the order for security or to protect them from intimidation or retaliation. And this may be satisfied where it can be demonstrated that there is a history of potential interference or quasi-interference with the justice system and the witness providing a full and candid account. Society's interest in encouraging the reporting of offenses and participation of victims and witnesses in the criminal justice system. And more recently, this theme has been captured by the Me Too movement in a broad sense, and society's collective desire to support individuals who come forward and report sexually related offenses without shame or fear of repercussion. And finally, any other factor that the judge or justice considers relevant. The final point being fairly broad in that unique circumstances of an individual and their desires or needs can be considered by a court on application under 486.1. As I indicated, there are a number of cases that demonstrate or identify that the recent amendments to the sections under 486, and specifically pertaining to the implementation of the word facilitate, has had the effect of creating a lower threshold in terms of the application to be made. Sections 486.1 sub 4 and 486.1 sub 6 are related provisions, and specifically sub 4 indicates that a judge or justice shall not permit a witness to be a support person unless the judge or justice is of the opinion that doing so is necessary for the proper administration of justice. And although it is not by any stretch the norm, there is case law where the parent of a child was allowed by order of court to be a support person. Sub 6 indicates that no adverse inference may be drawn from the fact that an order is or is not made under this section. And specifically pertaining to jury trials, there are standard instructions that are articulated to the jury where they are witness to a trial that includes testimony of a child or a witness via CCTV or behind a screen. They are specifically instructed that no adverse inference may be drawn from that fact, and that it is simply a tool meant to facilitate the taking of that person's evidence or the giving of that person's evidence, and no other presumption should be made or drawn as a result of the use of a testimonial aid in a proceeding. Next, Section 486.2 specifically provides provision for the testimonial aids, including a screen or CCTV. And similar to 486.1, the requirement for an individual under the age of 18 and a person who suffers from a mental or physical disability is different from that of individuals who do not possess any of those characteristics. And the requirement or test is essentially the same. The judge or justice shall, on application by the prosecutor or the witness, make the order for a testimonial aid where the individual is under the age of 18 or who is able to communicate evidence but may have difficulty doing so by reason of mental or physical disability. So again, the language is mandatory, meaning the order shall be made where the proposed witness falls into either category. And the exception, as was the case with 486.1, is that unless the judge or justice is of the opinion that the order would interfere with the proper administration of justice. And often here, if there is opposition to the order for a testimonial aid, the basis for it may include concepts that the accused has a right to come face-to-face with the accuser, and in a jury trial that there's a certain perception left with the jury that is not advantageous to an accused where a witness testifies via CCTV or a screen. In this particular provision, for 86.2, the order to be made is that the witness testify outside the courtroom or behind a screen or other device that would allow him or her not to see the accused. Importantly, this particular provision includes the word or, meaning either option is available, but the provision does not specify who is able to make the decision as to which facility should be used. and this has caused some amount of controversy in case law. As was the case with 486.1 sub 2, 486.2 sub 2.1 indicates that the application that was referred to in 1 or 2 may be made during the proceedings, before the proceedings begin, and additionally that any justice or judge having jurisdiction in the judicial district can make the determination where the proceedings will take place. So essentially, this section allows for the possibility that a witness may commence proceedings not wanting the assistance of a screen or CCTV, but at some point during the proceedings, that witness may find that the assistance of a testimonial aid will facilitate the truth-seeking function of the court or their ability to provide evidence. And vice versa, a witness may arguably commence with testifying via CCTV or with the assistance of a screen and subsequently wish to not use that facility any longer. The section contemplates that the proceedings are fluid and an individual's needs may change throughout. With respect to discretionary order factors, some factors are similar to that which is articulated in 486.1, and in particular, the age of the witness's mental or physical disabilities, the nature of the offense, the relationship between the parties, whether the witness has a desire for protection against intimidation or retaliation. And there are other provisions that are in relation to identification of a police officer in an undercover capacity. Additionally, as articulated in 486.1, society's interest in encouraging the reporting of offenses. And to be very clear, the discretionary order factors are those which the judge can consider on application of a witness who is not under the age of 18 or a person with a mental or physical disability. Not that these factors can't be considered in totality. It may be the case that even though the language of shall is mandatory, the prosecutor may choose to call evidence and demonstrate the need for any of the testimonial aids and may call evidence that addresses the various discretionary order factors. There is a distinction to be made between the mandatory language of shall and may, and the discretionary order factors are more relevant as it pertains to the discretionary orders. 486.2 indicates that there are specific provisions in relation to a hearing to be held where there is application to be made for a testimonial aid. It is clear that an expert is not required to testify in support of a testimonial aid. It may be the case that expert testimony is more relevant and necessary where an individual has a mental or physical disability that requires that they have a testimonial aid to testify. And that may be the case because that person's disability may not be apparent to the average observer and require further articulation from an individual who has assessed them. But generally speaking, there are a number of individuals who can testify about the need for a testimonial aid pertaining to a particular witness. And the case law has demonstrated that a variety of people have been called by the applicant, including a police officer, a social worker, a parent or family member of the applicant, a friend. In some limited cases, there has been viva voce evidence or affidavit evidence by VUOP or victim witness. And in some instances, the complainant, him or herself, may provide viva voce evidence or affidavit evidence. In those instances, it is not ideal or recommended that VUOP or Boost or the complainant, him or herself, testify on a hearing for a testimonial aid. And the reason is that the testimony in the case of VUOP or Boost may have the effect of compromising the ability of the victim witness support person or Boost support person to provide the supports that they were intended to do, because they have become a witness, and an order excluding witnesses may have the effect of not allowing them to provide supports as the trial proceeds. In relation to the complainant, him or herself, it is clearly not ideal that they testify at the hearing on application for testimonial aids, because it would fly in the face of the assertion that they're not able to provide testimony unless, of course, the testimony is provided via CCTV or using the screen. But in any event, it may be the case that the effect of the complainant providing testimony about why they need a testimonial aid may induce trauma unnecessarily, and at a point where they haven't been in a position to provide evidence on the actual offenses. As I indicated, the lack of specificity with respect to whom may make the decision about what testimonial aid to utilize has caused some amount of controversy in the case law. Some jurisdictions, including British Columbia and the Yukon, have decided that it is the complainant or the witness, him or herself, that chooses the testimonial aid that they are more comfortable with. It seems in practicality that individuals opposing the application tend to prefer a screen over CCTV because counsel would still be in a position to be in physical proximity and come face-to-face with the complainant or witness if they're physically present in the courtroom. Generally speaking, the practice is that counsel do not attend within the CCTV room with the witness, but rather that they question the witness, both parties question the witness via the CCTV while counsel are in the courtroom. On the contrary, Ontario, Manitoba, and Saskatchewan have made decisions that favor the opposite view, which is the trial judge chooses the testimonial aid to be utilized. There are clearly different reasons for each approach. However, when considering the purpose of the testimonial aid sections of the Criminal Code and the backdrop, including the victims, the Canadian Victims' Bill of Rights, and the UN Convention, it seems to me to be the case that it ought to be the victim or witness in particular that should decide what facility would best provide environment where they can provide accurate and meaningful testimony that advances the truth-seeking function of the court. Of fairly recent times, there has been a number of cases where specific rulings have been made in relation to support dogs. In particular, there are cases in Ontario and British Columbia where there has been judicial support for the use of a support dog. And interestingly, the criminal code articulates specifically that the section 486.1 impose a person as opposed to animal or any other thing other than a person occupy the position of support or be the subject of the order for support. However, judicial support, considering the underlying purpose of the section, has been supportive for the utilization of support dogs as testimonial aids. And in some instances, both a support person and a support dog have been imposed by way of order to act as testimonial aids for a particular witness. Generally speaking, there has been positive judicial treatment of support animals. In one case that I'm aware of, there was an imposition of an order in relation to a support cat, which was an animal that was possessed by the child witness in that particular case. And so the circumstances of that child and addressing specifically that child's needs resulted in the order for a support cat. But generally speaking, there is acceptance by the judiciary, at least in Toronto, in relation to support dogs. And the effect practically of support dogs in the courtroom has been a positive one for all parties, not just the witness testifying. Section 486 sub 1 addresses the exclusion of the public in certain cases. It is a section that is not particularly utilized in a common sense or regular sense, given competing interests of the public and the right of the public to view proceedings. And ultimately, the section considers and in particular, the justice considers of whether or not the order is in the interest of the public morals, the maintenance of order, or the proper administration of justice, or is necessary to prevent injury or to international relations or national defense or national security. It contemplates particular scenarios that may be more severe in nature. The factors on application are similar in some instances to previous sections, but in other instances consider items like the salutary and deleterious effects of the proposed order, and whether there are alternatives available in the making of the proposed order, again, because it's meant to be a fairly exceptional order. Section 715.1 deals with previously recorded evidence, and specifically this section requires that the applicant be under the age of 18 at the time that the offense is alleged to have been recorded. And so this section very much contemplates the evidence of children under the age of 18 and has some appreciation for the effect that a passage of time has on a child, considering developmentally what their ability is to retain information over a period of time. And in particular, practically speaking, a child of tender years or younger will not developmentally be able to retain information over the same period of time that an adult would. The requirements, though, of this section are not only that the witness be under the age of 18 at the time the offense allegedly occurred, but that the video recording be made within a reasonable time after the alleged offense. And the courts have contemplated, as we'll discuss in a moment, a reasonable period of time being 2 or maybe 3 years. And this proposes some difficulty with respect to instances where there is delayed disclosure. But otherwise, the requirements are that the victim or witness, while testifying, adopts the contents of the video recording. And that particular requirement has specific judicial treatment in relation to what adopts means. And so, again, the language indicates that this type of evidence can be admitted and form ultimately part of the testimony of the witness, unless the presiding judge or justice is of the opinion that the admission of the video recording and evidence would interfere with the proper administration of justice. The Supreme Court in LDO has articulated the purpose of 715.1. And again, specifically, this section addresses individuals who are children and under the age of 18 at the time the alleged offense occurred. And it is meant to accommodate the needs of young victims, that these individuals may be providing evidence in relation to a person that occupies a position of power dominance over that child. And the purpose is ultimately to make the entire proceedings less traumatic and stressful for a child, and simultaneously it aids in the preservation of evidence and the discovery of truth, because the general concept is that a child's version of events closer in time to the offense, to the alleged offense, is more accurate. As I indicated, the requirements of 715.1 are that 1, the video recording, and it must be a video recording, be made within a reasonable time after the alleged offense. The complainant describes the acts complained of within the statement, and that while the complainant is testifying in court, they adopt the contents of that same video. Reasonable time, according to the Ontario Court of Appeal in PS, has been articulated as 2 years, but there are other instances, other cases, such as SG, where a longer period of time was considered to be reasonable, and that specifically was 3 years. Other cases take different approaches. The case of LO provides assistance in relation to what the language of adopt means in this context. And specifically, the Ontario Court of Appeal indicated that adopts a statement within the context of 715.1 means when the witness recalled giving the statement and testified that when they were giving the statement, they were attempting to be honest and truthful. And that's to be distinguished from whether they're attempting to be honest and truthful at the time of the giving of the testimony. Now, of course, a child under the age of 14, prior to their testimony in court, promises to tell the truth, and then over that age, there is the administration of the oath. But as it pertains to the adoption of 715.1, it only need be the case that the witness was attempting to be honest and truthful at the time they gave the statement. The effect of the adoption of the statement, assuming that it is admitted by the court pursuant to 715.1, is that it becomes the child's evidence in testimony. So practically speaking, the prosecutor need not ask any of the same questions that the child was already asked in their previously video recorded interview. The purpose, again, of the section is to ensure, to minimize re-traumatization by a child by exposing them to having to re-articulate traumatic events that allegedly happened to them. So, in other words, the statement becomes part of the child's in-court testimony, as if the child were giving the statements on the videotape in open court. The child is still, of course, then exposed to cross-examination by defense, and it may be that the prosecutor need ask follow-up questions in relation to the statement, but ideally, those questions would be minimal. The court, of course, can exclude the statement if it would, quote, interfere with the proper administration of justice, end quote, pursuant to the section. So the judge or justice presiding over the trial still maintains the discretion to exclude or not make application under 715.1. However, the case law has been clear that that discretion to exclude the statement should be limited to cases where its admission would operate unfairly to the accused. And those cases would be relatively rare. And so, again, it is in keeping with the articulation of previous offenses discussed in this presentation under 486, where the language is different. It's not mandatory in relation to 715.1, but certainly there's contemplation of the purpose of the sections, and that is to facilitate the truth-seeking function of the court, to not re-traumatize, in particular, vulnerable witnesses such as children, and to address other concepts such as encourage the reporting of offenses, so that it's not the case that the process of the criminal justice system or the trial process has the effect of dissuading people from coming forward and reporting offenses, because the traumatization affected by that they will endure during the trial process has the effect of stifling reporting of these offenses. That is the completion of the presentation, and we are now in a position to take any questions if there are any. And I'm certainly, I've provided my information additionally at the end of the slide, and I am happy to answer any further questions, if not now, moving forward in relation to testimonial aids. There is one question, and I'll read the question. It indicates, will you address the use of a facility dog as a testimonial aid? So that question may have been posted before I got to the slide about facility dogs, and indeed it was. It is becoming fairly commonplace. The judiciary is well aware of the facilities as it pertains to support dogs that we have. Generally speaking, and I can only speak to the Toronto area, the facility dogs or support dogs have been very well received by our judiciary. The practical difficulty now is, given the number of cases where facility dogs are being requested, that there is a capacity issue or a resource issue about being able to have enough facility dogs to accommodate our witnesses who are requesting them for either witness preparation or for court support and otherwise. And certainly the slide that I provided lists some, but not all, of the cases where actual rulings were made in relation to the use of the facility dogs. Practically speaking, there is some concern from those opposing the use of facility dogs in the courtroom. My perception of it is that some of that opposition stems from a lack of information about how the dog functions in court. And generally, where there is opposition, there is some concern about whether the dog will be distracting to the witness. And the fact of the matter is that where a support dog is assisting a child in court, the position the dog takes, for example, if the dog is in CCTV with a child witness, is that the dog will sit by the feet of the witness and be available if the witness needs to interact with the dog, look at the dog, pet the dog, things like that. The dogs are generally very quiet, and in particular on CCTV, the jury or the jurist are not in a position to even see the dog because of the positioning of the video recording equipment. In the courtroom, it very much is court dependent. So a dog would sit in close proximity to the witness, and depending on the physical construct of the witness box, the dog may sit either just outside of the witness box or close to or even in the witness box in proximity to the witness. Sometimes the mere existence of the dog is enough support for a witness to endure their testimony, and there will be more interaction over breaks and whatnot with respect to the support person and the support dog and the witness, but it is very much dependent on the construct of the courtroom and the needs of the witness. If there's any other questions, I'm happy to answer them at this time. And then otherwise, as I indicated, I can be reached with via the contact information I provided on the last slide of this presentation. And if there are no other questions, then we'll be in a position to end the presentation.